what about the concern over a 4-4 split on the dispute about birth control? Major Garrett.
So the court asked this week, the various plaintiffs in the 7 cases that have come to the court dealing with what the Affordable Care Act requires in terms of providing contraceptive services and devices, and how that relates to religious institutions, nonprofits, and religious colleges who don't want to provide either that insurance company, those devices, or those services because it violates their religious moral perspectives. The court said, look, can we figure out a way to work around this? Can we figure out a way? And essentially the court said, we're not going to rule on this yet because we'd like to have some original thinking to figure this out. Can you figure out a way?
Unusual
it's very
move.
unusual for the court because usually the court says, here's a dispute, here's the law, here's the precedent, and here is our distillation of the law, the precedent, and the facts. In this case, the court said, is there another way?
Yeah.
And can you help us find another way, either that may involve Congress, may involve a regulatory change of the emphasis within the Affordable Care Act, or can private insurers, which the government says, look, you've got to work through the private insurers. This is actually the Obama administration saying we have to go through the private sector and the private insurers, not the government. But can you figure out a way to meet the requirement of the law, which is to provide contraceptive care and services through private insurers, but without forcing these institutions to notify them, pay for it, or do so against their objections?
Lisa.
The details here are so interesting, Diane. This comes down to a one-page document that these organizations need to sign saying we object to having to provide contraceptive coverage. That was an exemption the Obama administration came up with after the Hobby Lobby case. And the organizations, a lot of folks say, well, why don't they just sign that document and say we object to this coverage? What the organizations are saying here is very important. They're saying when we sign that document, when we say we object to carrying contraceptive coverage, that triggers automatically that coverage going into place by another health insurer. And we feel by signing that document, we are causing the very thing that we object to.
We're complicit in that process.
Exactly.
And that complicity is at the heart of their legal objection.
The mere fact that they're asking for this sort of compromise, and there actually seems to be a willingness on all sides to do it, again, I just think is fascinating how it shows that the court now, in essence, it's almost acting like a civil court. It's trying to bring everyone to some kind of a settlement,
right,
and not actually making a ruling because they're incapable of doing that.
We talk about judicial activism so much.
Exactly.
It's judicial mediation,
it is,
I guess.
And
I'm not sure.
It's almost like, as they always claim, legislating from the bench. You're essentially enacting a policy through the judges, and the Congress could step in and try to codify this compromise at some point. But again, it shows you, absent a ninth vote, this is the kind of stuff that's going to keep happening.
Now, in addition, you've also got the FDA